All right, well, I have like maybe 2 minutes before 1:30. Do we have everyone on this video conference that is scheduled to be here for the 1:30? If so, we could start just a few minutes early.
As far as I know.
Yes, Your Honor.
Okay, great, great. Then we will go on the record and cause number GC 16-00247, Samuel Adam Aflalio, I know I'm not pronouncing that correctly, versus Devin Lamar Harris et al. Mr. Suster, what is the correct pronunciation of his name again? I need to get that correct.
Aflalo.
Aflalo. All right, that will help me out. All right, thank you. So call this case. It is set today for the defendant's motion to transfer and to consolidate actions. I know there has been a response filed there too. May I have the parties just announce briefly on the record their names and who they represent?
Yes, Your Honor. Israel Suster along with Tyler Smith on behalf of the plaintiff.
Thank you.
Your Honor, good afternoon. Paul Genender and Janae, Jenae Ward from Weil, Gotshal and Manges for the defendants.
All right, thank you. Who will be arguing today your defendant's motion, Mr. Genender?
Your Honor, I'm going to argue it, but with the court's permission, I'd like to address the emergency motion to continue the summary judgment hearing first. Frankly, I think that really is the motion that we should take up today. I think that looking at the totality of the circumstances, the fact that they want to non-suit their claims, which they let us know in the other case last week, and thinking about what the evidentiary use would be for us of that case in the case before Your Honor, I think we, in the interest of efficiency and otherwise, I think we'll not pursue that motion. I don't think it's necessary at this point.
All right. Mr. Suster, any response?
I'm not sure what I'm responding to, because this is the second time that we've had repeated motions for both to consolidate, which we've responded to, and I think we've supplemented. And then we've had previous motions, emergency motions, I think, maybe I'm wrong, but emergency motions to continue summary judgment in this case. I mean, it's up to the court. Obviously, I have a response if we pursue any of those matters.
Okay. I guess let's start off real basic. Tell me what the emergency is.
Thank you, Your Honor. Paul Genender for the emergency is there's a summary judgment hearing set for a week from tomorrow, January 28th, on a motion, the second amended motion for partial summary judgment by the plaintiffs that was filed on January the 5th, and then set without conference as to the date for next Thursday. At the time it was set, filed and set, Mr. Aflalo's deposition was scheduled for tomorrow. And that had been scheduled. It was noticed in October and renoticed and moved from November until tomorrow because of a couple of things. One being the prior hearing on the motion for partial summary judgment, second being that Judge Lee directed us to mediate before Judge Pfeiffer, which we did. We made an offer of judgment, which we allowed to lapse or let the time come and go. And then we rescheduled the deposition. So first of all, they set the hearing in a manner such that we can't use the deposition. If we took it tomorrow, we can't use it because of this. Our response is due tomorrow, number one. Number two, their motion introduced new matters. It introduced the issue of the value of the property, which had not previously been introduced into the case by them, and in a new declaration or affidavit by Mr. Aflalo that we would need to depose him on, and also a new theory as to their damage model, different than what they had articulated before at any point in this case. So we do need his deposition. Why are we not taking it tomorrow, Your Honor? I let Mr. Smith, I believe I let Mr. Smith and Mr. Suster know some point last week that we need to reschedule for tomorrow for my personal reasons, and that my 86-year-old dad is having heart surgery tomorrow. So we're not, which is more important than any aspect of this case, certainly to me. So they're not, I don't think they're complaining about that at all, and I wouldn't expect them to. I've tried to get that rescheduled. I've suggested next Tuesday or Wednesday. I'm not wasting time there. I've suggested next Tuesday or Wednesday. I'm waiting to hear back. What I'm looking for, Your Honor, the emergency is because tomorrow is our response deadline to the motion as it's currently set. The emergency is that we want to have the hearing reset such that we can take the deposition. If it happens next Tuesday or Wednesday, then we need 14, 20 days after that for the hearing. We can get the transcript, file our response, and have it done in an orderly manner. The trial date is not until late April as a jury trial. And I hope for a lot of reasons that we're able to have a jury, if necessary, that we're able to have a jury trial before you in April, or anyone's able to have a jury trial before you in April. So it's not going to compromise that, Your Honor. I read in their response, they cited to a number of things that happened in the past. Your Honor, I think as we talked about last week, this is a different case than what was before Judge Mohlberg in 2016. The only thing that was before Judge Mohlberg in 2016 that was adjudicated was our claim that our motion on our motion for summary judgment on their breach of contract claim. We won, affirmed, flipped en banc. Okay, and then but we're here on our claims, our defenses to their claims, and we get to attack that. The Court of Appeals has not decided the issue of how much this property is worth. Any suggestion that they have is flat out incorrect. We're looking for it to take the discovery, take the deposition once, not twice, and come before you to have the most fulsome response. Now, we could, I guess, respond to the summary judgment and say this is what we can do based on what we have before us, but we don't have the benefit of Mr. Aflalo's deposition on these new matters he raised in his January 5th affidavit. Now, there's nothing wrong with him raising new matters on January 5th, as far as I can tell. We should be allowed to depose him and do it. Now, if they had said we're filing a motion for summary judgment when they filed it and said we want to get it set when is convenient for you, that would have been good. I would have said, well, let's make sure we have enough time so that we can use the deposition. That's really all we're asking for, Your Honor. So I'll stop there. I appreciate it.
Right.
And thank you for hearing us on an emergency basis. I don't file motions like that lightly. I will tell you, to Mr. Suster's comment, he did the same thing. They filed a motion back in September that Judge Lee said, no, go ahead and I want to hear it. You don't need a deposition before I hear it. And then I said, Your Honor, I'm in trial the date of that hearing. I've got another, and Mr. Suster literally, Your Honor, attached to a filing, a statement that he couldn't find a record of me having a conflict in Dallas or Collin County, as if I wasn't telling the court the truth. And I pointed out to Judge Lee and to counsel, and I would have told him if they'd asked, that yes, the matter I had was in Richmond in the Eastern District of Virginia in the J. Crew bankruptcy. That's where I was. So I'm not, I'm being straight up with the court, but, and then Judge Lee had the hearing. They eventually moved it a number of days, had the hearing, and didn't grant it. And one of the reasons he didn't grant it is because they hadn't pled damages correctly. And that's one of the things we want to explore before this comes before Your Honor, because as it stands right now, they still haven't, and I want to be able to discover it. So I appreciate it, Your Honor.
All right, Mr. Smith or Mr. Suster?
Judge, I'm going to handle it.
Okay.
I don't agree with 100% of what just was responded to in terms of what Mr. or Judge Lee say. But since you're now the third judge and new to this rodeo, I'm going to focus in on the narrow, on the emergency, and on the broad, because I think it's important to understand the perspective here. First of all, Your Honor, I I have served on the other side, and I have submitted to the court plaintiff's exhibits numbers 1 through 4, which I would represent to the court are true and correct copies of notices of deposition of Mr. Aflalo that were served by defense counsel. And I would move to introduce those into evidence. We've referenced them in our response, but I would actually like it of record.
Have I?
All right.
I don't know that I've seen those.
We've
He said they're attached to his response.
no,
exhibits one through-
we emailed them to the court.
Okay,
We copied, as far as I know, because I didn't do it myself, we normally would have copied you, but I will represent the council that plaintiff's exhibit number 1 is a true and correct copy of a notice to take oral deposition on Friday, October 30th, 2020. Plaintiff's exhibit number 2 is basically the same thing, except for it's November 18th, 2020. Plaintiff's exhibit number 3 is a notice to take the deposition for Monday, December 21st. And then plaintiff's exhibit 4 is a true and correct copy of the notice of intent to take the oral deposition of Mr. Aflalo, which was set for January 21st, tomorrow. And I would ask the court just to admit them for purposes of this hearing, assuming opposing counsel doesn't have an objection to my and if he doesn't have them, those are my representations.
No, I now see they were attached to an email that was sent to me this morning. They are. The notice for tomorrow was served on November 19th in response to being told that he's not available till middle of January, which is fine.
Your
So we
Honor, I'm
did-
going to object this. I'm just simply, if you want to object, I can respect that, but I'm just,
let
just-
me help move this process along. I see no reason in which not to admit those
Yes.
particular exhibits. They are notices of deposition. They're already a part of the court's record, and the court will definitely take notice of when someone was noticed and when there was a response. So they're admitted into evidence.
Great.
because one of the standards by the Court of Appeals and Texas Supreme Court is diligence. They're here on emergency, and we're now on our 4th one. The other thing I would point to the court, I don't know if the court has yet had an opportunity to look to our response, but at page 2, we give a background and we go through a date history of things that have gone through. For example, on September 11, 2020, where the court denied defendant's first emergency motion for continuance in other matters. Also attached is Exhibit 2, which is defendant's motion for summary judgment and brief in support that was file stamped on May 17, 2016, wherein it states, we kind of highlighted for the court, this suit is ripe for summary judgment. It involves a straightforward application of undisputed facts to the party's unambiguous contract. So what happens there is that this involves, and I'm going as to a overall background. I think that's important. This is and this is just info for the court. This has come out previously since you're a new judge, but this house was previously built by Roger Staubach. He lived there for his family. My client ultimately bought it, lived in it. Maybe he rehabbed it. He sells it to the Harrises. And then the Harrises basically, and this is all in the Court of Appeals opinion now, but there's, I believe, a 10-day period of time in which to terminate. They don't terminate. What they do is, they don't terminate then. They wait until the day before closing, and they give us a termination letter for the sole reason that our broker or we did not provide this boilerplate form called 1414. And they sued us for breach of contract on that. Long story short, we moved for summary judgment on what back was then, I think, specific performance, breach specific performance. They move on their summary judgment for breach based on the special kind of disclosure we had and saying that was a breach and they had a right out. Long story short, we get to the en banc opinion from the Court of Appeals, which was later briefed to the Texas Supreme Court, fully briefed, and the court comes out essentially in our favor. Comes out in our favor, agreeing that you're beyond. I don't have it in front of me, and it's been a while since I've read it, but essentially it says, you did wait too long. They go factually, you waited until after, and the termination, the 1414 wasn't a violation of the contract. They reversed the summary judgment and simply remanded. An important point to note, because a lot has been brought in motions to compel and their need is simply, they didn't buy the house. That's not in dispute. So we have a contract, and what contract defenses do you have? Now, this is a case that's now going on in its fifth year. And I'll represent to the court, as I recall, Judge Lee at one point has repeatedly said, this is a simple case. He didn't say one way or the other. And we moved on liability at the time. We had damages in there, but we didn't really address. And there were some other issues brought up in which the court said, I'm not going to grant and I'm not going to deny either way. There was some issues they raised. For example, I think I remember, did we mediate this before? So what we decided to do is coming back before this court, because we are asking for liability for damages at this point, but the court can can grant liability, can deny as a damages, try it if it wants. But the point is that we've teed it up. Most of the facts haven't changed. So we get back to, they want our deposition. And the evidence before the court is, they have been, and look, this is my opinion, but I think if you go back and look, the evidence will bear it out. The judgment against us that we had to appeal, the attorney's fees were whittled down to $185,000 against us. That was appealed in the judgment originally. It was like $185,000, which, as I recall, a diminution for well over $200,000 at a time where we're at $30,000. And my point is, they've been throwing the kitchen sink at everything we do in this case. They did not buy the house. There is, I don't know, when they say there's fraud and they relied on fraud, they've never indicated to the court, trial court, and the Court of Appeals on this. And as I understood from Judge Lee, he didn't comment except to say, this is a very simple case. And I think at the end of the day, that this is a simple case in that it involves a Texas Association Realtors contract that gets litigated, and either we have either they breached by not closing, or they have a contractual defense, which our position is they don't. They asserted it, and that got appealed, and damages and attorney's fees. Now, those are fact issues, and they've had 5 years to develop. This thing was reversed and remanded some time ago. I believe we've disclosed the damages, and at one point, I don't recall as of the last time, what the judge had us do, or the court had us do after the summary judgment. He says, has this been mediated? I'm going to order you over to mediations. Have you mediated with Judge Pfeiffer? Do you know Judge Pfeiffer? And he ordered us to go mediate. So everything, we kind of put everything down. We didn't move forward, and we waited until the mediation. And so obviously we now have, there's a change of people at the helm. And so we're now with a third judge. No, nothing against this court in any way. We're happy to have the court, but we're now 3 sets of times explaining versions and going back and forth against each other in the same court, and it gets a little bit tough. And my point
Let me
is
just,
that
let me just ask this question, and certainly I can understand the frustration with having a lot of judges sit in the seat and having to go back and forth, but I want to try to stay just very narrowly focused on the issue. And if what I'm hearing now is, I think my question initially was, what is the emergency? And what I've heard from you thus far, counsel for the plaintiff, is that diligence is an issue for the defendant. But what I haven't heard, or what I would like you to just mention to the court briefly, your position on whether or not there's new evidence that has been presented. Because we know that if this court is going to grant a motion for an emergency motion to continue it, I have to be persuaded about diligence, and I have to be persuaded about whether or not it is truly new evidence, or whether or not someone is just seeking more time.
I'm not sure what they say new evidence, because our pleading has been this way for years now, or a long time. And we've disclosed, we've just not ever gotten to the point of a summary judgment. And this time we actually put an affidavit from our client as to the fees. And so the question is, they've never, my point is that what am I supposed to do? We tendered him. He was ready to go on October 30th of last year, I believe. They canceled it. I think Mr. Smith might remember it better, but it was like the day before, maybe, or 2 days shortly before, where we actually had discussions with our client in preparation, and they cancel it. They notice again, they cancel it. They notice again, they cancel it. It wasn't, they have had an opportunity to take it. So there is no diligence, in my opinion, to show that we have in any way precluded them from being able to take his information and get evidence. I don't understand what the new stuff is, that they countersue us for fraudulent inducement, or they start making all these claims on things which we don't get. Like, they start asking insurance policies on flood insurance. Well, if you read the nature of what was taken up, had to do with, we've disclosed floodplain, we've did this. We just didn't give them 1414. And so they, just getting back on point, I'm not sure I understand what the new evidence is. There is evidence that we have proffered to the court, and it's for them to, if they disbelieve the evidence that we've proffered on there, it's for them to counter with that and create a fact issue. It is what it is on that. They can disagree. We have a value on it, or what we indicate, and if they disagree, they are free. They are free to challenge that and offer whatever their evidence is. I don't know why that's necessarily a problem.
All right.
Your Honor, can I respond to the question? May I respond to your question, Your Honor?
Yes.
Okay. Diligence. We were mediating with Judge Pfeiffer and discussing resolution, and decided to pursue an offer of judgment as an extension of mediation. That's there's a notice of that in the court's file. That's why the deposition didn't happen in October, late October or November. When we asked to reschedule it in November, Your Honor, we were told no dates till January. We got it rescheduled. The truth is, they didn't file their new motion until January 5th. They waited, and Your Honor, they waited and they filed it after they knew that the deposition was scheduled on the 21st, and by setting it on the 28th, that we couldn't use it. You asked about new evidence, Your Honor. Mr. Suster answered a lot of things, but he didn't answer that. The affidavit, I'm looking at the court filing. This is an exhibit to their pending second amended motion for summary judgment of Samuel Aflalo in paragraph, if I can get there, bear with me. Paragraph 11, by way of example, he offers an opinion of value of the house for the first time. Paragraph 10, he offers an opinion of damages for the first time. That's the new evidence, Your Honor, in a nutshell. I can go on, but that's enough. That is enough. That is enough. He didn't answer. You asked twice. He didn't answer it. Mr. Suster didn't answer. He wants to talk about a lot of things, and I've listened to a lot of nasty things he said, and I'm not going to respond to the nasty things because I want to answer your narrow question. That's the new evidence. We need to take the deposition, and we will then want to have the hearing an orderly time thereafter. Their prior motion wasn't granted because of a pleading defect, and that's why it wasn't granted, because they didn't even allege damages, let alone show them. Okay? And the truth is, Your Honor, to point to something we said in a motion that was granted in 2016 that we brought on when the case was differently postured on a different issue is apples and oranges. We get to bring the claims we want to bring. We get to bring the defenses we want to bring. The Court of Appeals certainly didn't say, gee, you're not entitled to make a fraud claim based on them not providing you flood insurance or them not having flood insurance when they told you they did. And if they did have flood insurance and were claiming that they didn't, then they should just produce the policy that we've moved and is before that issue is before the court, of course. Your Honor, to suggest, gee, these fraud claims weren't addressed in the Court of Appeals is a red herring. That wasn't up before the Court of Appeals. They'd lost on their case. They were appealing and we were responding to their appeal. We didn't have an opportunity or a need to bring counterclaims because we had already won. So I think we talked about this. I know the court knows this. And we just want something that's the emergency. I submit we have exercised diligence. I submit undertaking ADR at the direction of the court, undertaking to try to resolve it, undertaking to use the offer of judgment rules, to which we've received zero response. Your Honor, I emailed these lawyers Monday evening when I was getting emails from them. I emailed them twice about this emergency. They got my emails. They read my emails. I know I have that. They never responded substantively. Mr. Suster Tuesday morning said, Mr. Smith will let you know. No one let me know. I asked about a new rescheduled deposition date. No one's let me know. I get it, Judge. I can't force them to communicate with me, but to come in and throw a bunch of mud against the wall against us is not productive to this issue, which this is a fundamental due process issue. And I want the court, what I think everyone wants the court, is to make a decision with the right evidence in front of you, a complete summary judgment record as opposed to an incomplete one. That's it. They have major problems in their case. I want the opportunity to discover and get that information in front of you. And I'm not. The Texas Supreme Court and the rules do not limit me to the evidence that he puts in 20 days before his motion is set for hearing unilaterally. New evidence. They never have evidence of that before. And it's certainly never been in an affidavit before, and I should be able to depose the affiant. Thank you, Judge.
Let me ask this, and I'll let you respond to that, counsel, before we wrap up this particular hearing. Does the court have appropriate orders for the hearing today? And that's the emergency motion to continue the summary judgment?
You do from us,
the
Your Honor. Yes.
How about from the plaintiff?
Mr. Smith, have we tendered anything?
Plaintiff has not tendered on that particular motion.
We will get something out to the court after we're done here today.
Okay, I'm going to give you an opportunity to respond.
Yesterday, Judge, I've got a hearing and I've got a brief due in the Court of Appeals. I get an email and I send opposing counsel and I let him know this, and then I will talk to Mr. Smith. The next thing that I'm aware of yesterday is motion filed, hearing set for today. That's not an atypical way of the way this thing has gone in terms of hearing cases. They filed a counterclaim in this, the very beginning on this. They had to have prevailed on everything and determined all the issues in order to get this as a final case so that we can get it up to the Court of Appeals. So I don't understand that they say, and I don't understand what they say. There weren't any fraud allegations. Everything, the termination was solely given on Form 1414. This is all, and if you read, I recall a passage in the opinion that says that the facts aren't basically in dispute. They're pretty clear. And the opinion itself goes on to say what the facts are. Now they change up the entire ball game and there's something new, somehow fraudulent inducement, which is a whole new application here. The other thing I would ask the court is some statements are made by counsel that we didn't move or allege. The court can easily go and look at our prior motion for summary judgment on there and what we moved and on liability. We moved on liability, not on damages. You can set forth damages and you can have an allegation of damages. You don't have to prove up damages, only that you were damaged. It could be $1 or $10. And we put that information in there. At the hearing, and I don't want to relitigate this, they made a claim, well, the contract required us to go and mediate. Yes, it did. We didn't address that, but I think we put that in our in the latest MSJ. So in terms of diligence, Your Honor, this is a straightforward case. There's no new evidence that we have proffered. If we had gone to trial, if we were, and Judge, we were set for trial in March, by the way. It was reset. So we were moving forward with anything. And they had opportunity to get discovery. We did not prevent them from doing that. That's a problem with their diligence, and I've got that evidence into the record. We've proffered evidence now. Instead of just moving on liability, we're also moving on damages. And we've given an affidavit on that. If they want to rebut, if they think those aren't the damages, they can accordingly. Taking his deposition isn't going to necessarily change his position on damages. They are what they are. And either they're going to come in and they're going to have their own set of damages. And if that's going to be a fact issue we have to try, so be it, Judge. But
any response to value of the property being new and presented for the first time in this affidavit?
Well, it's the first time we tender an affidavit on the specific damages because it's like trial. And if we were at trial, it's true. But if they had taken his deposition, presumably they would have asked him what his damages are, and they could have found that out. There's nothing wrong with me. It's not like he's changed his testimony or there's something new here that's completely different at the end of the day. And by the way, Judge, the damages are the difference between the price, which we've given them this information all along. Very simple. There's a contract with his client for a certain amount, and then there's a contract with a party that ultimately bought it about 7 months later. Because after they breached, we ultimately put it on the market. We sold it. There's a difference in value, and we've given that information over to them at the end of the day. And I think that's the number. I believe that's the number that we're using. Is that correct, Mr. Smith?
Correct.
Yeah. So in terms of evidence out there, that's been our position in the difference in value, and they've had the contracts. We've given that information to them a long time ago. So I don't understand I don't think they've met the burden for purposes of a continuance of the summary judgment on diligence. And yes, it's in the affidavit, but it's the evidence is the difference in the value. And that's the number that we're using here for the court. So should be no surprise. And they could have gotten that information had they just simply took his deposition in October, and we wouldn't be in this, they created their own problem.
Okay. All right. Let me say this with respect to the hearing. First, I want to make sure, I know we referenced the prior hearing. Did you all receive the order of the court on the motion to compel?
No.
Okay. All right. I know that they have been doing some painting and computers got unplugged. I will send a note to Karen because that is signed to make sure that gets pushed out to you all. So I want you to know that that part is completed. But with respect to today's hearing, Mr. Smith, if you would be so kind to make sure that you all have an order uploaded so that the court can review it. I understand the deadlines that you all are under. You will have an order from me today. I will not leave the courthouse until I get you all in order because I know you all are working with the deadline on tomorrow. And then Mr. Janinder, I just want to make sure that the defendant intends to, I guess, reset the motion to transfer and consolidate to another date, or just don't.
We're not going to pursue it, Your Honor. I'm
Okay,
not
so
gonna
it's being
pursue it.
pulled down.
Yeah, I don't want to, we're not going to pursue it because I don't think I need to. I think I can deal with that evidence in your court without having it consolidated since
Okay.
they non-suited. Your Honor, the paragraphs I was referring to in their summary judgment that was filed on January 5th, I mean, it's paragraph 10 and 11 are brand new, brand new. And I think counsel said they were new.
Well, I will take a look at that and you all will have
Thank
an
you.
order today.
Thank you,
I
Judge.
have a question, Judge.
Yes, sir.
And I'd like to get clarification because at the last time we had a hearing on this and the motion to consolidate and transfer, I thought it was withdrawn during the same thing that we're going through. And then it was reset. This is the second time that we're having a hearing on it. And so I just want to be sure I have an understanding that they're withdrawing and this is done, or are we, and that we don't have to mess with this again.
Your Honor, I'm happy to respond to that. Mr. Suster, I don't think sometimes gets some of the facts right. It was set before Judge Lee. I told Judge Lee, should we deal with this on a different day? He kind of indicated yes. I said, we'll reset it. But I actually said, just to be clear, I said to Judge Lee, I'm assuming no one's going to take action in Judge Smith's case before I get this reset. And he said, correct. And that's when they actually filed a non-suit last week which is in contravention of what Judge was said on the record before Judge Lee, that we filed an objection and we had this reset. But Your Honor, I've said, I know the difference between resetting it. You asked me, I was very clear. We're not pursuing the motion. It's withdrawn. It's withdrawn. I'll say it one more time. It's withdrawn. But Judge, what I do want is an opportunity to present our defense fairly. And I so thank you for ruling today because frankly, I don't want to deal with this case tomorrow because I can't. So thank you.
Okay, I just wanted the clarity so I can put the notation in the court's docket. But I think that's everything that I need. And I think that concludes our hearing. I have a 2 o'clock waiting on Zoom. So I appreciate it and look forward to receiving the orders. Okay.
Thank you, Judge, for your time.
Thank you, Judge.
Take care. Bye-bye.
Hello.
Good afternoon.
Good afternoon.
Howdy. Sorry, we just finished the hearing before you, so she should be back on in just a moment.
Good afternoon, Your Honor.
Good afternoon. How's everyone?
Well, I'm staying away from the COVID, so that's got to be good.
That has to be great. That has to be great. So
Have they given you guys any shots
safe.
yet? Have they given y'all any vaccine down there?
They have made vaccines available at Parkland to county employees, especially those that are interfacing with the public. So they have been made available. But I still need to figure out how to get the rest of my family vaccinated because we have children that are doing online and in-person school. So still a threat when we have the little ones coming in and out of our house.
That is my grandkids.
Yeah.
It's kind of we've got 2 that are from Houston, 122 who's down at actually just 21 who's in Austin, and his sister, and we had not seen them in literally 6 months, and my wife has been involved in a cancer situation and immunity issues, and She finally had surgery 3 days before Christmas. And so they showed up over here, I guess, 2 weeks after she'd come home, or 2 weeks after the surgery. And our daughter, who's very concerned about this, said to her, "Mom, you can't even let them in the house and this kind of stuff."
Right.
So Bev said, "You know what? So what? Come on in." And hugged both of them and said, it is what it is. And they tried to stay safe, stay home. And you just have to live your life through some of this stuff. And, bless your heart with kids. I don't know how many you've got at home and how many friends they've got that they hang out with. But
Yeah, well, it's a very tough time. It's a tough time for everyone. And it's tough trying to have a 17-year-old to understand that you can't do a whole bunch this year. I'm sorry. You can't hang out with friends. It's just us. And
Judge, at 17, you're bulletproof.
they think they're bulletproof anyway.
Well, aren't you?
For a little bit. So, well, let me go ahead and get you gentlemen started on your particular hearing. I'm Judge Monica Purdy, the new judge of the 95th District Court. So nice to meet you all. I have a 2 o'clock hearing. We're going to go ahead and get it on the record at this time. Cause number DC 20-06657, ViewTech Incorporated versus Supreme Bright Fort Worth III LLC et al. May I have the parties announced at this time? Simply let me know your name and who you represent.
Yes, ma'am. I am Bob Holmes. I represent ViewTech.
John
Thank you,
Ivy,
Mr. Holmes.
representing Supreme Bright Fort Worth III LLC, Supreme Bright Plano II LLC, Newcrest Image LLC, Mehul Patel, and Mitel Patel. And myself, since there are sanctions being, or accusations involving sanctions regarding my conduct in this case.
Okay, well, thank you. Thank you for that announcement. I'm pulling up your case. It's set for the plaintiff's motion for sanctions. So I will let Mr. Holmes go ahead and present his motion to the court at this time, and then I'll give Mr. Ivy equal time to respond.
Your Honor, thank you. It troubles me to file a motion for sanctions against an attorney. Let me start saying that. Let me further start to say that, I am acutely aware that when pleadings are filed, they're presumed to be in good faith. This is a case that involves an engineer, a structural engineer, who was engaged by the Patels to provide structural services for 2 proposed hotel projects. As things went forward, and they chose not to go forward with the projects, and then told my clients that we'll pay you when we can. They're trying to stay alive during the COVID situation, and to carry a debt of this amount is really not appropriate. And so they talked with them and couldn't work it out. And Mr. Lisiak, president of ViewTech, calls me and says, "Look, let's sue these guys." And we were surprised at the response. We filed a suit and a fairly quick motion for summary judgment based on sworn pleading. The response to that, Judge Lee, after hearing the protestations of Mr. Ivy about needing discovery and looking at some affidavits that Mr. Patel had signed, suggested to me that we not go forward with the first motion for summary judgment because the hurdle was so high, he didn't think I could jump that high. Well, when a judge tells a lawyer that, you pull your motion. That's what I did. The statements that Mr. Patel made and Mr. Ivy urged were, although it's unclear how much, if any, work was actually performed by plaintiff, defendants never received the structural engineering plans, details, and specifications. We knew that wasn't true, and did not expect such a response in a sworn affidavit. The second statement he made is not clear, however, that plaintiff did not deliver to defendants the structural engineering plans, detailed specifications based upon the scope of the work. Then he goes on and makes the next statement, and these are all in my motion. Besides plaintiff's failure to deliver to defendants all the structural engineering plans, detailed specifications, reason it is unclear how much, if any, work was actually performed. Well, these are so contrary to the evidence, Your Honor, and I did not attach the affidavits that are attached, the declarations, to the third motion for summary judgment, which was filed on January the 5th. The architects on these projects providing absolute clear proof and evidence in sworn form that those documents were delivered to them the minute they got them. They were considered on both projects, every item. There was no exceptions. They did extra work, no exceptions. And it is just unreal to me that Mr. Ivey wouldn't have done enough research to look into that before he filed that answer, number one. And Mr. Ivey told me on the first summary judgment that he'd gotten hired 3 days before he had to file an answer, give or take. Am I right, John? Is that about right? You were
That's
just
correct.
engaged and asked for time. And I said, I don't do that. These guys have had plenty of time to respond. It was about 60 days. And it was a sworn pleading, which no timely response had been filed to, sworn to. So again, Mr. Lee allowed that, which took away the sworn account basis for this lawsuit. So we're back. And basically what's happened, Your Honor, they have been, by making these false allegations, they have kicked this can down the road now about 8 months. And that's just not what we lawyers are supposed to do. We have a duty and an honor to the court not to allow our clients to come in and intentionally mislead the court. And they did this twice. The second summary judgment, I didn't attach it in the form of evidentiary form. I attached it to Mr. Lisiak's affidavit, the email showing the proof of delivery of this stuff. Mr. Ivey again urged the same declaration that Mr. Patel had signed the first time, and then objected to our evidence. And he was crying, and he had the right to do that. But the fact is, they re-urged the same. We didn't get it. We don't know how much work to do. We don't know it. And of course, a court's not going to grant a summary judgment based on that. But here, looking at Exhibit C and D to the motion for summary judgment, those are third parties, 2 architects who worked for both on both projects for the Patels. They came in and they took their records, attached their records to their declarations. And although Mr. Ivey wants to argue that we have not presented credible evidence to show that there's actual fraud, actual misstatements made to the court, and in my position, absolute bold-faced lies, because Mr. Patel had seen those. If you look at Exhibit C and D, you will see attached to those as exhibits, there are emails to Mr. Patel. Here are the documents. Here are the engineering plans. Here are the structural designs. We need to make changes. Here's a potential cost based on this structural design. Oh, okay, so we don't want to do concrete in Fort Worth now because that's too costly. Let's do steel. They went back and got an amendment, another $50,000 cost to completely design the structural part of the building. And yet these guys just don't want to pay. And I understand that. And there would have been, back at one time, the ability to work that out. But today, Mr. Lisiak is just incensed that people would lie to the court and mislead and take up the court's time on stuff like this, when there could be a reasonable solution to where everybody would get paid and everybody would do things on a timely basis. And that hadn't happened yet, Your Honor. And we're asking for our attorney's fees and sanctions. And we believe that the sanctions are available both against the attorney and his client, because Mr. Ivy did not, in my opinion, do his due diligence. Should have come in and made a comment to me, early on. I don't know when he got hired, actually. I think his law firm has represented these people for years and does a lot of their transactional work. And I think this got thrown on his desk at the last minute. But that still does not beg the question of a lawyer having a duty to review what his client files, and then seeing evidence to the contrary allows it to be filed again. And that's what troubled me, and seriously troubled me. So Your Honor, we asked the court look at this, and 10.1 is there for the purpose. Chapter 10 is there to prevent this kind of stuff, prevent lawyers and their clients from intentionally misleading a court for the sole purpose of kicking the can down the road, raising the cost, and doing it for nothing more than I need time. And there are other ways to get that. So I thank you, Your Honor.
Thank you. Mr. Ivy, response?
Yes, Judge. I don't run into situations where people accuse me of fraud. I'm an officer of the court. I'm licensed in the state of Texas to practice law, and I take a great deal of pride in that. And usually when we have commercial disputes, I'm usually on the plaintiff side. Being on the defense side is not something I do a whole heck of a lot. But ordinarily, we put the facts in front of the court and the court decides. There are a handful of things that I need to correct. First, the motion for summary judgment that was originally filed was brought within 6 weeks of the time that my answer was due. I did object to it, and I asked for a continuance. Now, the continuance, Mr. Holmes left out kind of an important detail. The continuance was granted based on evidence that I had served him with discovery, roughly contemporaneous with my answer, and he had not responded yet. On that basis, your predecessor granted the continuance. Now, I did as we all do as lawyers. Hey, they're suing you. They're saying this. What's the story? What really happened? And my client's position is reflected in their statements. Now, Mr. Holmes, as soon as he got a copy of those statements, as soon as they were filed in response, has sent me not 1 or 2, but 3, and I've printed them out and kept them, emails raising the holy hell with me about my clients being liars, and he was going to drag all of us in on a motion for sanctions if we didn't settle right away. The bottom line is, Judge, this isn't the way that our canons of ethics and our bar association in the Texas Supreme Court mean for us to practice law. You raise your client's position, I raise my client's position. If one is proven to be right and the other one's proven to be false, that's one thing. But no deposition has been taken of me or my clients to get down to anything more than what is put in their affidavits. They stand by those affidavits. I have no reason, after looking at their correspondence and their evidence that I've been presented with by my client, I've been presented with no evidence to make me believe that they're lying. Now, the other bits and pieces of this that I need to correct are more factual than anything else. My clients didn't hire Mr. Holmes' clients. My clients hired and signed contracts with 2 architectural firms that were supposed to design these buildings from A to Z. Those firms told us that we needed structural, architectural, they have others, I suppose, best I understand it, is sub-disciplines of architectural design. They have this particular group, Mr. Holmes' clients, that do the type of architectural work that they do. They were supposed to act as subcontractors for the 2 architecture firms because my guys aren't architects. They need real architects to look at these other guys' plans and see that they work with the overall plan. And along the way, there were problems. Now, the reason we're here is not to argue the motion for summary judgment. The reason we're here is to see whether or not Mr. Holmes has presented this court with the evidence it needs to find that, well, essentially, that my clients have committed perjury and that I have somehow suborned that perjury, or in the alternative, that I failed to exercise enough diligence to ascertain whether my clients were telling the truth. Now, that's actually a higher burden than what is set forth by the Bar Association. If you look at the disciplinary rules, which I pulled out when I got this motion for sanctions, what we're supposed to do is abstain from suborning perjury. In other words, suborning a position that we know to be false. And there is an onus on us to do more than simply take our client's word at face value, but it ain't much. Now, Judge, in this particular situation, Mr. Holmes is, instead of attaching them to his motion, he's referenced 2 unsworn declarations that are attached to his motion for summary judgment, his 3rd motion for summary judgment. And Your Honor, I'll go on the record right now objecting to those because they have attachments to them, and they made no effort to prove up those attachments, either through a business records affidavit or some other exception to the hearsay rule. And so I'm going to object to that, number one, because it doesn't comply with our rules of evidence to and admissibility. And I'd like to get a ruling on that, Judge, before we get off the Zoom meeting. But the second thing is, even if Mr. Holmes is correct and the architectural firms that acted as the general contractor for this structural architectural firm, his client, and even if they made these plans available online to my client, that scenario does not make their statements false. Mr. Holmes included 2 individuals with by the way, no claims in this lawsuit that are against them individually. The only thing he's done is drag them in and slap them with sanctions because he didn't like what they said in those statements. And now they and I are up in front of the court for sanctions. Judge, if it were this easy for me to get the other side in trouble every time the other side's clients disagreed or said things that were exactly opposed to what my client was saying, I'd be in front of judges all the time on sanctions. You know that. This is not how we were intended to practice law. And the bottom line is Mr. Holmes has fallen far short of establishing a burden by presenting evidence that either my clients knowingly lied to the court, that I purposefully misled the court, or that I have done anything else that violates the canons that control our practices that would warrant $25,000 in sanctions. Oh, and I'd need to ask for a ruling on the objection to hearsay.
Right. I was going to ask for Mr. Holmes' response as to the objection. There's been an objection lodged to the statements contained in your motion, Mr. Holmes, being hearsay. Do you have a response?
Well, those motions are not hearsay, Your Honor. They are the unsworn declarations of William Duncan. Mr. Duncan is WDG Architect PLLC, and he makes his own statements about what he did specifically, not what somebody else did, not what he heard from somebody else. And to his declaration, Your Honor, he attaches exhibits that he wrote and sent them to Mr. Patel, or that Mr. Patel wrote and sent them to him. Those are not hearsay. If I testify to what I'm saying, I give an affidavit that attaches an email that I've sent, that's not hearsay. That in and of itself is my statements. I'm providing that evidence. Mr. Mr. Duncan goes through his affidavit or his declaration and basically states that he was informed that the Patel Group had in fact hired UTEC, and then asked that the invoices be sent to them, reviewed by them, and that, quote, Mr. Patel stated, "We will pay him directly." That's attached as Exhibit 1 to Exhibit C. Again, that is an email between he and Mr. Patel. He is not testifying as to what some third party told him. He's testifying to what he received in an email to him. That's not hearsay. Then he goes on further and speaks and provides specific evidence in the form of a document that monitors his sending and receiving of structural designs from the various components. And it's not just a structural engineer, an architect. There's the MEP, there's the structural, then there's the foundation, and there are other disciplines that work for this. So these architects are sort of the if you will, the gatekeeper or the switch track keeper, and they take all this information and provide project information. So that is as to Exhibit C, Mr. The affidavit of William Duncan. Exhibit D is affidavit of Mrs. Rowland, and she was the architect in charge at the other architectural firm. And again, she testifies as to what she actually did with Mr. Patel, and what her role was in this. And again, not what some third party in that architectural firm did, but what she did and the communications she had. And both of these affidavits almost track each other, although with two different individual firms, but the same thing. They all say that the structural engineer services were necessary, that they were provided, that UTEC had been engaged by the structural engineers and by the Batels. They didn't hire them. They weren't subcontractors. They were gatekeepers, and that's all. That and it again. I don't know how you can object. I mean, how you can sustain an objection on a declaration where a person is testifying and providing written documents that they are a part of as hearsay. And both of those are the same, Your Honor.
All right. Mr. Ivy, just a brief response to what you've heard counsel represent to the court, that it's not hearsay because it's not a third party offering it, but what they said.
Judge, I'll point out the last attachment page to Exhibit C, which is page 51 of his pleadings. This, I am guessing, has to do with the software that keeps track of, or at least, and I'm guessing this because it doesn't explain what it is. It doesn't say, this is not an email that Will Duncan drafted. It's a screenshot of some sort of computer spreadsheet. He doesn't prove it up. He doesn't truly explain what it is, and it's not a communication from him. And I understand what Mr. Holmes is saying. There's some of it that is communications from my client, which is, not fall within the hearsay prohibition. And there's some of it that he could prove up by simply saying, I sent this email. But there's somebody else in here named Gary Mills that's part of the chain. There is spreadsheets that are in here that are not explained, and he doesn't say that he drafted them, prepared them, wrote the software, did anything about them. It's something
let me say this with respect to the objection. I know that you filed a response to the motion, Mr. Ivy, but obviously, if there's detailed information in the exhibits as you are representing to the court would like to look at that. So I think the appropriate thing and the proper thing to do would be for counsel to upload an order with respect to the objection that is raised, the hearsay objection, and which particular exhibits. And that way there will be a order on file with respect to the court making a ruling as to whether or not those are hearsay objections contained therein. So
Good,
let me
Judge.
just
I'll do
direct
that.
you to do that. And in light of you uploading that order, obviously, if the court is wanting to spend some more time with the detail of those exhibits, it's not going to be able to provide a ruling today on the hearsay objection. But once your order comes in, I will rule on it that way.
Thank you,
Let me
Judge.
give Mr. Holmes an opportunity to sort of have final words as it relates to the motion for sanctions. And one thing that I do want you to cover, Mr. Holmes, obviously you are moving for attorney's fees. And I guess I would need to hear the amount of work that you did on this motion. And then if Mr. Ivy obviously wants to offer any testimony to possibly rebut that presumption, I'll hear from you briefly in which to do so.
Yes, ma'am, Your Honor. It is actually in my affidavit.
Okay.
And let me get over here. It's attached to Exhibit B, and I haven't gotten quite adept as some of the other judges I go before in not using paper to find something I'm looking for. But in dealing with just this motion for sanctions, Your Honor, and I explained, and I think the court knows, rates in Dallas County for guys with my experience and Mr. Ivy's experience are $350 to $750 an hour, depending on the discipline in which you're working. And in this particular discipline, I believe $500 an hour is reasonable, and that's what I charge. Through the filing of the motion for summary judgment, I've spent 108 hours on this case. If you take that apart for just the motion for sanctions, I've got somewhere in the neighborhood of 22 and a half to up till this morning, until we go to this hearing, including my response time for that, somewhere between 22 and 25 hours related only to the motion for sanctions. And if I wanted to be unfair to Mr. Ivy's clients, I would try to take all of the efforts that were put forth on these affidavits and stick it over on the motion for sanctions, but that's not what I'm doing. That was time that was spent over on the motion for summary judgment, and it's applied to the motion for summary judgment. So I had to do some research. I had to go through this thing. The fact is, I initially filed a motion for sanctions along with the first motion or the second motion for summary judgment. And Mr. Ivy, that motion was set for a disposition by the court. Apparently Judge Lee wanted to handle things. I don't know whether it's the new way or the old way, but some judges handle it by disposition in motion for summary judgment, and some don't. I'm sort of in the middle and don't really care. Summary judgments are what they are. So anyway, I then separated it, and quite frankly, most of the hours were spent back then. Once we got these affidavits, I sort of incorporated them. I did not take the time or burden the court with extra paper, although it's digital, with attaching those affidavits directly to this motion, because I believe I have the right to refer to them, and this court can see them. They're filed in the papers of the cause. And so 25 hours, Your Honor, is what I'm saying, and at $500 an hour. And that would come off of this for a standpoint of what we go for in the entire summary judgment here. And so that's what I'm asking for.
All right, Mr. Ivy.
No cross-examination, Judge.
Okay. All right. Mr. Holmes, do you have an order that has been uploaded with the motion for sanctions for this court? to
I don't
review?
think I uploaded it, Your Honor. I think I just sent it to the court coordinator and reporter yesterday, and I got all messed up on days when with this past week, and was
Okay.
intending to do this on Friday and woke up Monday and went, oh gee.
No problem. No problem. Then if it was sent to the coordinator as well as the court reporter, then the court will take it that way. Mr. Ivy, do you have an order? I know we talked about the order with respect to your objection, your evidentiary objection, but do we have just a general order with respect to the motion?
Yes, Judge.
Okay, all right. Then the court will pull that down. The court will review this. You all should have a ruling from this court by tomorrow. The way that you will receive this court's ruling is the coordinator will push out a copy of the orders that I do enter to you all via email.
Okay, will Mr. Ivy, you'd ask Mr. Ivy to file some formal objections to the evidence.
No, I asked him to file an order with respect to his objection on hearsay. He raised a hearsay objection.
Yes,
With
ma'am.
respect to the statements that were contained in your motion. I'm going to review those particular statements, take a look at the exhibits, and I'll make a ruling on his hearsay objection.
I got you. Okay,
Okay.
I'm sorry. Thank
All
you.
No problem. Is there anything further?
I'm good.
Okay, Mr. Ivy, anything further?
No, Judge.
Okay, then that concludes our hearing. Thank you, gentlemen. Take care.
Oh my gosh, I wasn't right.
You see that? Rosie, all forget her.
How did it hurt? Did you look up the medicine thing and see if you have it?
No.
Okay, well, I'll have to look when I'm done. You can look though too. Hello.
Hello.
Hey, can I get y'all's cause number real quick to make sure I have the right one? Because a couple hearings canceled.
Sure, of course. Let me pull it up here. Tell me when you're ready.
I'm ready.
DC 20
Uh-huh.
17048.
Great, thank you.
Hi, Com.
Hi, how you doing?
Okay, just sit tight. We'll get started here in a second, okay?
Okay.
All right, good afternoon.
Good afternoon, Your Honor.
All right. I'm running a little bit behind on my hearings. Do we have everybody that we need to go forward with respect to the default prove-up?
Yes, we do, Your Honor.
All right, Mrs. Rouse, are you ready to take the record?
Yes, ma'am, I am.
Okay, great. We are on the record then in cause number DC 20-17048, Com Siripana versus Liquid Cargo Incorporated. May I have the parties announced at this time? Let me know your name and who you represent.
Javier Gonzalez, I represent plaintiff Com Siripana.
All right, Mr. Gonzalez, thank you. All right, and will can you pronounce his last name for me? I want to make sure that I'm pronouncing that correctly.
Yes, Siripana.
Siripana, just like it looks. So,
Exactly.
Mr. Siripana, welcome to the court, the 95th District Court, virtually as you will. I think that your lawyer is probably going to ask you some questions as it relates to this particular lawsuit. But before he asks those questions, I am going to swear you in about the testimony that you will provide. So if you could raise your right hand for me, Mr. Siripana. All right, Mr. Siripana, do you solemnly swear and affirm that the testimony you're about to give will be true and correct to the best of your belief and knowledge? If so, say I do.
Yes.
Yes? Okay, thank you.
Yeah.
You can put your hand down, and Mr. Gonzalez, you can call your first witness.
Thank you, Your Honor. May it please the court. I call Mr. Kam Siripana to the stand.
All right,
May I
Mr.
proceed?
Siripana. Yes, you may proceed.
Thank you, Your Honor. Sir, would you please state your full name for the record?
My name's Cam Siripana.
All right, Cam. And you understand we're here about a lawsuit you filed regarding an automobile wreck you're in on April 21st, 2019, correct?
Correct.
Okay.
Yes.
I'm sorry, what was the answer? I'm sorry, I didn't hear it. I couldn't understand his answer.
Can you ask
Go
me
ahead
the
and
question again, Mr. Gonzalez?
Sure. Cam, you understand we're here about a car wreck accident that happened on April 21st, 2019, correct?
Yes.
Okay. And you understand we filed the lawsuit, and the record, I believe the court's docket will reflect that Liquid Cargo Inc. was served and has not filed an answer. So I'm just going to ask you some questions about the accident, okay?
Okay.
All right. So the date of the accident I show to be April 21st, 2019, correct?
Yes.
And that happened here in Dallas County, Dallas, Texas, correct?
Yes.
In fact, you were driving an I-20 when this other vehicle changed lanes into you, correct?
Yes.
And just, Your Honor, this is not an exhibit, but I'd like to show my client, the witness, a photograph of his vehicle after the accident, if that's okay.
Yes, that'd be fine.
Okay.
Can I share the screen or no? Am I allowed to do? Yes, I am. Okay.
I think we just have to let the court reporter know, and she can let us know when you're allowed to share the screen. I think she has to do something on her end.
I
Yeah,
did, Judge.
Okay,
Okay.
you should be able to.
Okay. Your Honor and Cam, do you see the vehicle picture on their screen now?
Yes.
And Cam, is that a fair representation and photograph of your vehicle after the accident we're here about?
Yes.
All right. And you understand there was a police report made regarding this accident, correct, Cam?
Yes.
And the police report only faults the other vehicle for this accident, correct?
Yes.
Whose fault do you think this accident was, yours or the other driver's?
The other driver.
All right. Now, it's my understanding after this wreck, you went to the emergency room, correct?
Yes.
And there you had some lacerations, some cuts on your head and your face, correct?
Yes.
And they had to give you some stitches to heal you, correct?
Correct. Yes.
All right. And then besides that, after that emergency room treatment, you had some follow-up care with some different medical facilities, correct?
Yes.
And in fact, one medical facility in particular you saw was Foundation Physicians Group, correct?
Yes.
And again, I'm going to share the screen, Your Honor. And I'm going to show you this just to refresh your memory, Cam. You see on the screen, it says here Foundation Physicians Group.
Yes.
And then it talks about the injuries to your cervical or your neck. Do you see that?
Yes.
And in fact, your medical providers at Foundation Physicians Group recommended a surgical intervention, a cervical discectomy and fusion, correct?
Yes.
And then down below, they gave an itemization of the total cost for that fusion. And they said the estimated cost for everything having to do with that surgery would be $351,791.71, correct, Cam?
Yes.
All right. Cam, besides, your neck, well, let me ask you, besides the lacerations to your head, what parts of your body did you feel were injured in this wreck?
My neck, my shoulder, my elbow, my back.
And as you sit here today testifying in court, albeit virtually, on a scale of 0 being no pain, Cam, and 10 being the worst pain you ever felt, would you tell the court on average what your pain level is like every day?
3 or 4, 3 up to 4.
Also, Cam, would you describe to the court how your day-to-day life, what you do, has been affected or limited by your injuries? For example, you talked to me about going for walks. How long, before the accident, how long could you walk for?
I can walk for like 2 or 3 hours.
That was before the accident, correct?
Before the accident, yes.
And now, since the accident, for about how long do you feel like you can walk for before you have to stop?
10 or 15 minutes.
Okay. What about lifting things? Before the accident, how much could you lift if you had to lift something around your house, for example?
It's around 50 or 60 pounds.
And what about now since the accident, Cam?
15 or up to 20 pounds, that's it.
And what about, could you tell the court how your sleeping has been affected at night, your sleeping?
Yeah, it's kind of pain, so I get a hard time to sleep.
Okay. And then lastly, Cam, what about standing or sitting for long periods of time? Can you do that anymore?
No, not anymore, somewhere like 20 minutes, something like that.
Okay, and
Usually
before that, oh, sorry. Before the accident, Cam, how long could you stand for?
4 or 5 hours.
Okay. All right. Your Honor, I believe that's all the questions I have for my client. I would pass witness, but there's no other counsel. So unless Your Honor has any questions, I'd like to allow him to be done. But if you have any questions, Your Honor, of course, feel free.
Sure. I have just a few questions. They're probably directed more towards you, Mr. Gonzalez. I have a copy of the proposed default judgment that has been submitted to the court. And with respect to the medicals that are there, I want to make sure that I have those correctly. And just to make sure, the default judgment that was filed with the court, there's not been another one that has filed since that particular one. Do you know?
We actually did file an amended one this morning, Your Honor, when I saw that there was not a slot for future medical costs. If I could forward it to Your Honor right now if you'd like me to.
No, what I can do is I can have the clerk to pull down the one that was submitted this morning. If there are blanks in that one that was submitted this morning, I want to know what those blanks are and understand what you are asking for.
Absolutely, Your Honor. Let me make sure I'm looking at this correct document then. Okay. So on that amended, and it will be named amended default judgment, Your Honor,
Okay,
in slot A, and this is per the medical records and affidavits filed with the court previously, respectfully ask for medical costs paid or incurred in the amount of $23,944.81.
okay.
And then if I could take it out of order so you can understand where I'm coming from, Your Honor, is that okay?
No, that's fine.
Slot F or blank F on that will be future medical costs in the amount of $351,791.71.
Okay, and that is with respect to the affidavit that you showed the court with respect to the fusion surgery that is required or recommended.
And full disclosure, Your Honor, it is my understanding that that future cost estimate for the surgery, while from that provider, was not included and attached to the affidavit. But
Okay.
That's why I did make the point of showing it to my client to prove it up today as his understanding of that's what it would cost.
Okay,
I
all right,
don't want you to think I'm misleading the court as to being attached to the affidavit.
no problem.
So then backing up to slot B, Your Honor, past physical pain and mental anguish.
Okay.
And again, just so Your Honor can understand, on behalf of my client, given that he's had this neck pain every day since the date of rec in 2019, and given that it's been constant, we respectfully ask the court for $250,000 in past physical pain and mental anguish.
All right,
For slot C, future physical pain and mental anguish, because of the recommendation of a neck surgery of a 2-level fusion, we respectfully ask for future physical pain and mental anguish in the amount of $500,000.
okay,
Slot D, past physical impairment. Given the limitations he's described every day since this wreck, we respectfully ask the court to award $250,000. And slot E, future physical impairment. Because again, going back to the recommendation of a 2-level fusion and all that will entail, we respectfully ask the court in slot E for future physical impairment, award the amount of $500,000.
all right. Is there anything else?
There are no other slots, Your Honor, and in all candor, he did have the lacerations on his face, and if Your Honor would like to insert the word physical impairment, physical and impairment and disfigurement in slots D and E on the amended order, I would respectfully ask the court to do that, or I can submit another order with separate slots, but I don't think that's necessary, unless Your Honor would like that.
No, I can review what has been signed, and with respect to D and E, it's physical, and what was the other type of impairment?
Physical impairment and disfigurement
Okay,
for D and D. So past physical impairment and disfigurement, and E, future physical impairment and disfigurement.
okay. The court has that down and will make that appropriate interlineation on the order. So what the court is going to do is the court will grant the judgment. It will review the amended default judgment that has been filed. It will make sure that it goes through the different subsections that you just spelled out to the court and insert those in and get those awarded. You can anticipate me doing that by today. I will do it before I leave the courthouse, so the clerk should have it uploaded for you to be able to view the signed default judgment either by the close of business today or first thing in the morning.
Thank you very much, Your Honor.
Okay, and I think that concludes our hearing. Mr. Siripana, I just wanted to wish you good luck. I hope you are able to recover from this incident, and just tell you to be safe, okay?
Thank you very much.
All right, you're welcome. I think that concludes our hearing, Mr. Gonzalez, unless there's something further that you might need of the court.
No, Your Honor. I guess I would only ask if we may be excused.
Yes, that'd be fine. Thank you so much. Take care.
Thank you, Your Honor. Are we still on the record?
We can go off the record.
Just off the record, I'd like to congratulate Your Honor on taking the bench and your win in November. And congratulations.
Thank you. Thank you. Very much appreciated.
All right.
That concludes our hearing. So everybody's excused. Take care.
Thank you, Your Honor. Com, we can leave now.
Okay.
Right. You like, no, no. Back in court. Hello, Mrs. Rouse.
Hey, Judge.
Hello, how
Sorry.
are you? No, 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 that's okay.
Good.
3:15, motion to withdraw. I show it set for a Zoom hearing. Nobody appeared on that one?
No, ma'am.
Okay, I'm gonna jump off. Let's just keep the Zoom open. If they jump on, just send me a message and I'll get back on, but I'm gonna try to work through some of these orders that I have, okay?
Okay, yes, ma'am. I've left it open. I was making my son some bagel bites real quick while we were in between.
Okay, no problem. I'm gonna
All right.
leave, and if they come on and join us, then let me know. If not, then I'll jump on at 3:30.
Okay, will do.
Thank you.
You're welcome. Hello.
Hello.
Are you here on the 3:30?
Yes, ma'am.
Okay, just making sure.
American Express versus Christopher Sage.
I guess so. It's the only one we have, 3:30.
Yeah. Okay.
I just knock the calls number down because I'm from home. It's easier to just not have to jot all that down.
Okay. Yeah. The cause number is DC 20-04200.
Yes, sir.
All right. That's the one. I'm here.
Okay, awesome.
No, not really.
All right, good afternoon.
Good to see you again, Judge.
Good to see you. Mr. Spence, do we know if Mr. Sage is going to be joining this particular hearing? I know that he is pro se. Have we had any conversations with him?
I have not. He had an attorney, Mr. Tom Thomas, which I have the utmost respect for, and he was forced to withdraw because of ethical reasons, and so I don't know that raised a red flag for me. So
Okay, let's go ahead and, but we don't, he's not here now. It's 3:30. He had a lawyer. And you've not had any conversations with him about this hearing. Is that correct?
that's correct.
Okay, give me just a moment to bring your case up. All right, Mr. Spence, we'll go ahead and get started. We are on the record in cause number DC 20-04200, American Express National Bank versus Christopher Sage. Will you announce for me at this time your name and who you represent?
This is Eric Spence on behalf of American Express National Bank plaintiff.
Okay. And just so that we have a complete record, Mr. Spence, your motion for summary judgment was filed on, is that November 24th, 2020 with the court? I'm just trying to make sure we're within the 21-day period.
Yes, it's been on file for quite some time, Your Honor.
Okay, all right. So it was filed on the 24th of November. When did it get set for hearing?
Ooh, that's a good question. I know we
Looks
sent
like
out
there-
we sent out notice of hearing on the 13th of this month.
Yeah, it looks like there was an amended notice of hearing that was sent, but it looks like that was done at the beginning of December. So, okay, that still gives us enough time.
We attempted to do an MSJ hearing, and I think there was a mix-up between the login numbers a week ago or 2 weeks ago.
Okay, all right. And if you will also be so kind to put on the record any notification. We talked about the notice of hearing, but what type of notice did the defendant, Mr. Christopher Sage, receive with respect to the motion that's set before the court today?
We always send them both certified mail and through the USPS.
All right. And did he actually sign the green card or did it go unclaimed?
I believe it says COVID on it. I don't think the USPS is too keen on knocking on doors trying to get signatures right now, but they put COVID on it.
Okay.
I believe.
Okay. And did you also say that he was served by regular mail?
Yes.
Okay. And did you have any mail returned to you?
No.
Okay. All right. Just wanted to make sure that he was noticed every way that you knew how to notice him with respect to this particular hearing. All right. Let's go ahead then. At this time, you can go ahead with your motion for summary judgment. I have the motion pulled up here. If you have any evidence that you would like to proffer to the court will entertain that at this time.
Great. This is just a basic credit card case. Mr. Sage applied for a credit card. We issued him one. He used it and subsequently defaulted. As evidence, we've submitted Exhibit 1, which is this business records affidavit from our assistant custodian of records in California. We submitted Exhibit A, I believe, which is the card member agreement, which is basically the contract between American Express and Mr. Sage. And finally, we submitted the Exhibit B, which is the most recent payment statement. Based on that, I would ask the court to award the amount of $26,756.21, plus the cost of the court, no attorney's fees, and no interest.
All right. Anything else?
I believe that's it, Your Honor.
All right. Okay, the court will review the proposed judgment as soon as we conclude this particular hearing. It intends to grant the judgment for the amounts prayed for therein. I will make sure that that gets to the clerk today. So it should, when I say it gets to the clerk today, she'll scan it in and it should be available for you to view either by the close of business today or first thing in the morning.
Understood.
All right. Is there anything further that you need from the court?
That should be it, Your Honor. May I be excused?
Yes, you may. Thank
All
you.
right, great,
Good to
thank you.
see
Take care.
Take care. Bye-bye.